The Fourth Amendment was created in order to protect the people from the government unlawfully being able to come into their home after the British would commonly do this through a writ of assistance. The Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The Fourth Amendment directly relates to the right to privacy. While the right is not explicitly defined in the Constitution or Bill of Rights, it can be inferred from a series of amendments, including the First, Third, Fourth, Ninth, and 14th. It was first defined in 1890 by the Supreme Court as the right to be left alone, and has now developed into a liberty of personal autonomy protected by the 14th Amendment. Recently, there has become widespread debate over the ability of the government to access a person's personal information, such as phone calls and emails. Fremont Weeks was using the mail to send lottery tickets and was arrested. Police then searched his house twice without a search warrant and seized more evidence to convict Weeks. The Supreme Court had to answer the question of did the search and seizure of Weeks's home without a search warrant violate his Fourth Amendment rights. The court ruled that the search of Weeks's house and seizure of Weeks's property was illegal. It was in this case that the court created the exclusionary rule, which prohibits police from using illegally seized evidence in a trial. This rule strengthens the Fourth Amendment. At the time of the decision of this case, the rule only applied to the federal government and not the state governments. Federal officers were greatly limited in their power in pursuing criminals, and they now need a search warrant to search a home and seize property. This helped many people preserve their right to privacy. The federal court system now had to dismiss all evidence that was obtained illegally. The exclusionary rule has been applied in several other court cases and has prevented many people from being wrongfully imprisoned.
In Denver, Colorado, Julius Wolfe and two others were accused of conspiring to perform illegal abortions in the mid-1940s in the city and county of Denver District Court. At trial, Wolfe claimed the evidence used against him couldn't be used because it was obtained illegally. The court ruled that because the trial took place in a state court, the court did not have to abide by the exclusionary rule, and that the exclusionary rule therefore only applied to federal courts. This was a big ruling for federalism because it separated the powers of the federal government from those of the state government, but it was a terrible ruling for U.S. citizens. Because illegally obtained evidence could now be used in state courts, Fourth Amendment rights could essentially be ignored. If an officer can seize anything they believe associated with someone suspected of a crime and use it, there's no reason to get a warrant, which is a direct violation of the Fourth Amendment. This resulted in many people in state courts to be unfairly imprisoned across the 50 states. Dalray Mapp was believed by the authorities to be harboring a fugitive. The police illegally searched her home for the fugitive, and while they were there, they found porn and other obscene materials. They arrested Mapp for these materials, but she appealed her conviction on the basis of free speech. When the court was ruling in this case, they didn't pay much attention to the fact that these materials could be classified as free speech, but instead focused it on the fact that these pornographic materials were obtained illegally. The court ruled that since the materials were illegally obtained, they could not be used as evidence, which overturned rulings such as Wolfe v. Colorado, which said that all evidence was admissible in state courts. This ruling limited the freedoms enjoyed in the 12 years prior by police officers, where they could take and use evidence that they got illegally. However, they now had to be issued a warrant to seize anything that may be used as evidence in a state court and federal court.
Griswold was the executive director of Planned Parenthood in Connecticut, and she gave information and other medical advice to married couples about birth control. Both Griswold and the medical director at the Planned Parenthood were prosecuted under a Connecticut law that made it illegal for any person to use anything that would prevent conception. Griswold sued against the law, and the court had to decide, does the Constitution protect the privacy rights of married couples against state restrictions on the ability of a couple to be counseled and educated on the use of contraceptives? The Constitution does not say whether or not the people have a right to privacy. However, through the First, Third, Fourth, Ninth, and 14th Amendments, the Supreme Court interpreted that there is a constitutional right to privacy, and in this case, there was a constitutional right to marital privacy that was created. Therefore, the Connecticut law and other state laws were ruled unconstitutional. Furthermore, this case was significant as couples have the right to educate themselves on contraceptives, and it gave women more power over controlling their own bodies. As a result of this case, there have been an increase in publicly funded contraception programs at both the state and federal level through Title X and Medicaid that have helped lower-income women control the size of their families and respect their right to privacy. This has caused for a reduction in the number of abortions and unwanted pregnancies. Charles Katz was using a public phone booth in order to gamble. Federal agents had wiretapped the phone booth and he was convicted based on the recorded conversations. Katz argued that this was a violation of his Fourth Amendment rights, despite there being no physical intrusion. The court had to answer two questions in this case. Did the use of evidence found in the wiretapped conversations violate the Fourth and Fifth Amendment rights of Katz? And is a physical intrusion necessary for it to be considered a search? The court ruled that Katz was protected by the Fourth and Fifth Amendment, as his conversations were private and it is not necessary for there to be a physical intrusion for it to be considered a search. This strengthened American citizens' right to privacy, however it restrained the abilities of law enforcement to pursue a criminal. It is now necessary for both federal and state agents to have a warrant in order to wiretap a phone. This case also overturned the decision in Olmstead v. United States. However, many believe that this Supreme Court case decision has been overlooked in recent years as the government has collected mass data and tracked GPS without a warrant. The political cartoon depicted here relates to the Supreme Court case of Katz v. United States because it is mocking the unnecessary use of technology and invasion of privacy by the FBI to wiretap a public payphone. It can be inferred that the cartoonist believes that people should have their rights be better protected as the man in the phone booth is having his privacy invaded by federal law enforcement.
The incident of Terry v. Ohio took place in Cleveland, Ohio, where John W. Terry and two other men were checking out a residence, most likely with the intent of staging a robbery, according to a plainclothes Cleveland police officer. After the officer saw the three men and determined that they were acting suspiciously, he frisked all of them and found weapons on Terry and one of the other men. Terry appealed to the Supreme Court, saying that his rights were violated because a search and seizure conducted by the officer was a violation of his Fourth Amendment rights because the officer didn't have a warrant. The court thus considered the question, was the search and seizure of Terry and the other men legal under the Fourth Amendment? The court ruled in favor of the officer, saying that he had reasonable suspicion and did not exceed the scope of his duties to keep himself and others safe. This ruling gave more power to officers to keep themselves safe and conduct searches without a warrant, as long as they were reasonable in doing so. This decision also expanded some rights taken away from officers regarding obtaining evidence in cases such as Mapp v. Ohio.
The political cartoon pictured here relates to the Supreme Court case of Terry v. Ohio, as the cartoon mocks how cops are supposed to do something as originally ruled by the Supreme Court, but then the court later decides to change their stance on the issue. The cartoonist definitely believes that the cops should be more controlled in what they are able to do, and the rights of the people should be better protected.
Roe v. Wade could be considered by many to be the most controversial Supreme Court ruling ever. In 1973, Jane Roe, a woman from Texas, wanted to have an abortion and end her pregnancy, but it was illegal in Texas at the time unless the birth of the child would be hazardous to the health of the would-be mother. Roe was granted a writ of certiorari to the Supreme Court, and the court debated the obvious question: does the Constitution give a woman the right to end her pregnancy? The court decided 7-2 that yes, it does, under the right to privacy. A woman could terminate her pregnancy before the end of the second trimester without worrying about government intervention in all 50 states after this ruling. This decision still causes debate today, and conservative groups are always trying to overturn it. It has also inspired later cases such as Webster v. Reproductive Health Services and Planned Parenthood v. Casey, which increased specifications of legal abortion because Roe v. Wade was rather broad. On the other hand, many groups are fighting to protect a woman's access to abortion to this day, and the debate continues.
Tia Lowe was a high school student who had her purse searched after she was caught smoking in the school bathroom. In the purse, the school official found cigarettes, marijuana, and a ledger. Tia Lowe believed that the search was unreasonable as there was no warrant. The Supreme Court had to answer the question of, does the exclusionary rule pertain to searches administered by school officials in public schools? This court ruled that the search of her purse was reasonable, as school officials are allowed to search students as long as the officials have reasonable suspicion that the student has something illegal on them. This ruling reduced the rights of students from unlawful searches and their right to privacy while in school. At the same time, it gave more power to school officials to be able to search students. The federal government has stayed out of the issue of searching students while in school and has left the decision to the states and towns to determine. For example, in Cheshire, part of the job of school officials is to protect all of the students under their authority. They can search lockers and other spaces that are provided to the students, as those areas are school property. It is only special circumstances when the safety of students, school staff, or property is at risk will a school or police officials search a student and possibly seize evidence.
In Dow Chemical Co. v. United States, Dow Chemical had denied the EPA a follow-up investigation of their outdoor facilities in Michigan. Even after Dow denied the request, the EPA conducted an unauthorized investigation which involved aerial photographs of the outdoor facilities. When Dow brought the case before a district court, the court ruled that it violated Dow Chemical's expectation of privacy. This question was just appealed to the Supreme Court. Did the EPA violate the Fourth Amendment and the expectation of privacy if they were only inspecting outside facilities? The court ruled 5-4 for the EPA. They said that since the facility is outside, Dow couldn't reasonably expect privacy because it bore similarity to an open field, where privacy isn't guaranteed. The court ruled this way also because the EPA didn't use any technology only available to them to take the photos. Rather, they used cameras usually used for map makers. As far as the impact this had, not only were aerial searches of any kind without the use of outlandish technology now legal, but this also firmly said warrants by both state and federal officers were not needed to search outdoor areas, which affects the way law enforcement officers can operate and obtain evidence. This greatly expanded the abilities of law enforcement to search an open field for evidence, while it reduced the rights of the people under the Fourth Amendment in all 50 states.
The police had a warrant for the arrest of Rodney Gant due to driving with a suspended license. After being arrested, his vehicle was searched and the police found cocaine and a gun. Gant asked that he not be charged for the cocaine and the gun because the search was done without his consent or a warrant. The court had to determine whether or not a search conducted by police officers after arresting the defendant and securing the scene was a violation of the Fourth Amendment's protection against unreasonable searches and seizures. The Supreme Court ruled that it is a violation. The police are able to search the vehicle of the owner if the person arrested can possibly access the vehicle during the search, or if the vehicle can possibly have evidence that relates to the offense of the arrest. Otherwise, the police must have a warrant or the driver gives them consent to search the car. The court said that warrantless searches are unreasonable and are only limited to very few exceptions. After this case, both state and federal officers do not have as much power to search a person's car, and the individual has their rights more protected. The court system has used the decision in Arizona v. Gant to rule other searches and seizures unconstitutional.